100,000 spots or so to Ukrainians to settle temporarily in Canada, and more recently, a pathway for some of them to settle permanently in Canada. And you see that further with issues in 2023 with Sudan, where there's a policy to facilitate extending their status. Sudanese visitors or workers who are in Canada can extend their status with much less difficulty and less government fees. And similarly with the issue in Israel and Gaza, there's 1,000 spots right now that are available to Gazans and Israelis affected by the conflict to be able to settle temporarily in Canada. So this also comes to another point that I like to emphasize with immigration and citizenship law and refugee law as well, and that is that there is a hierarchy of law, regulation, and policy. So the law, namely the main one being the Immigration Refugee Protection Act and Citizenship Act, and those pieces of legislation are obligatory to be followed by the Canadian visa officers or citizenship officers. And similarly, the regulations are binding on the Immigration and Citizenship Department. But then there are the policies, and I've given you some examples thus now. And those ones are supposed to be faithful to the immigration and refugee laws and policies, but they are ambiguous and they're time sensitive, and there is some inherent ambiguity to those because they are meant to cover a temporary situation. And that's where things like, other policies like those related to granting spouses of students in Canada work permits or giving a post-graduation work permit is gigantic policy, basically. And it sometimes has the effect of being binding, as if it's a law, but sometimes courts say that these policies are to be interpreted flexibly, which causes a little bit of confusion, which is why that's why immigration lawyers are a thing, and that's why there were 16,000 federal court leave applications filed in 2023. So that gives a sort of broad sense of what people may face, at least in a broad spectrum, for any kind of application. So I invite you to pose any questions you have in the chat, and I'll try to address them in as much detail as is reasonably possible. In some cases, if you pose a question in the chat and it's a little bit short on details, then I'd want to ask for a bit more detail during the course of the discussion. And on top of that, if there's a follow-up, sometimes there's a logical question arising from my answer, then please feel free to pose that in the chat as well. I'll take a look at the chat for the moment and see what if anything is going. Okay, so there's nothing here at the moment, except, oh, wait, I see something right away. So just for the sake of the recording, the question is, how long does it take to get your permanent residency if you have IRCC visa? So I'm assuming that is, how long does it take to get a permanent resident visa if you have a temporary visa? In terms of background, maybe you could text if it is a visitor visa or visitor record or work permit or anything of that nature, right? So it looks like it's a work permit. So there is a number of factors that affect the timing with immigration, and that relates to the category. And it sounds like, based on the text, the points, there's a point total of, it looks like 800. So that's a reference to based on the quantity of the number, that's a reference to the comprehensive ranking system that governs the inventory of applicants seeking permanent residency under the economic categories, such as Canada Experience Class or Federal Skilled Worker or Federal Skilled Trades, or many of the provincial nominee programs, which are often integrated or weaved into the Express Entry comprehensive ranking system. So, in terms of further background, as probably the texter will know, that the Express Entry system is subject to draws typically every 2 weeks. And those are preceded by you placing an Express Entry profile into the system. And the profile has a précis of your English or French and work experience and education. And that leads to a particular score. That candidate has a score of 800. And so one factor that governs when you would get PR is when will you get selected for an invitation to apply for an electronic application for permanent residence. And based on the previous scores, they've been creeping up. So, for example, since about July 2022, they have been above 480. And then there was it looks like there was a glitch in October where there was not a draw. This led to an increase in the CRS score of over 500. So, in a situation where you have 800, which sounds like you either have a certificate from a province or you're an executive level person with labor market impact assessment, then in those cases, it seems that it's inevitable that you'd get selected very shortly after you file the Express Entry profile. And then in terms of what happens next is the invitation to apply is essentially the requirement to file electronically your application for permanent residence, usually within 60 days, along with admissibility documents like a police check. And in the general scheme of things, the immigration department is supposed to take 6 months from the date you complete your EAPR, or electronic application for permanent residency. Unless, of course, there's an issue related to medical or criminal or another admissibility. But in that case, you'd really want to consult with a lawyer, because then you may have more significant issues than a run-of-the-mill permanent resident application. So I hope that provided some scope, general, and a bit of specificity to your answer. And then I would try to proceed if there's any other questions. And I see one, which is this person has applied for a visitor visa while in Canada online. And the estimate is 14 days online, I presume. But it looks like the person made a query with the immigration department at the number, which I think is still 1-888-242-2100 if you're in Canada. And was told by an agent of the immigration department that the visitor visa will be processed outside of Canada, since the person's status inside of Canada, which is a visitor record, is not a work or student visa. And that led to the discovery that this visitor visa, which normally takes 14 days, will have to take the processing time connected to the office where it shall be sent by the immigration department. In this case, the visitor visa application will be sent to Egypt or Cairo. So the question is, what can be done to expedite this? You can see with immigration, there's a built-in kind of discrimination based on where you hail from and what your status is. So essentially, because Canada wants workers and students in Canada, they have a pathway to have a TRV, or visitor visa, processed very quickly. By contrast, if you're in Canada only as a visitor, then the processing time is much longer. It's connected to your country of citizenship or country of ordinary residence, leading to the processing time. Presumably, the person is from Egypt or a country that the Canadian Visa Office in Cairo deals with. And that leads to the 155 days. So, in situations where you want to try to figure out how to expedite a visa of any sort, the the lines of communication with Canada's immigration department are very narrow and very inefficient. Arguably, this is by design because of the sheer quantity of visa applicants Canada has, perhaps 1 million applications per year if you count visitor visa applications, and study permits and work permits and PR and etc. So, with that premise in mind, that they only want to reach out to you if they have a query, the entire system is meant for you to file everything at the outset, which means to have a slavish adherence to what is on the standard document list for whatever you're filing. Make sure it's precisely followed, and then you're subject to the ordinary processing times. So, what do you do if you want to make it go faster? What avenues are available to you? So, if you are inside of Canada yourself, sometimes you can approach the federal member of parliament where you reside and ask them if they have any insight. This is supposed to be part and parcel of what federal members of parliament do. So, they should have an assistant working in their office, which should have some expertise. Anecdotally, in the recent past, they're not helpful. It's not their fault. But further in the past, maybe 10 years ago, it was quite sort of a courtesy that the member of parliament could try to get the government notes on your file on a faster basis, faster than we could. I don't see that functionality with members of parliament these days, from what clients are telling me. And oftentimes, members of parliament are stuck as well now, just because the sheer number of people trying to avail themselves of some kind of permit or visa or privilege under Canada's immigration laws. So, aside from that, there's the standard web form, and based on my experience and what clients are telling us as well, they only will respond if they have good news, namely that it's going to be done soon. And the norm, unfortunately, is that they may not even adhere to their sort of standard response time, which is supposed to be 28 days, but rather you may not even get a response for this. So then you have to weigh in your mind what is the significance or benefit to you or detriment to you to try to make this go faster. Is it extremely important to you? Another way of saying that from a legal lens is, what prejudice do you have if your case is not decided in a timely way? And that has to be a substantive prejudice. There's certain types of detriments which are recognized in the law, like perhaps maybe this status or needing clarity on this status would allow you to acquire some other kind of activity like work or study in Canada. Or maybe in a more extreme case, for example, in a group of 5 overseas refugee case, for permanent residency that is delayed, you can fairly make the case that the people being sponsored are in a refugee camp and their children are suffering because they don't have the benefit of schooling. And that could be the basis for making a request to expedite. But then the other question related to this is, what do you do Well, I mean, unfortunately, the only avenue available is the web form. So you would explain this prejudice in the web form with hopefully with evidence, because as you may know, you could attach screenshots of evidence and things of that nature to the immigration department. And then in the normal course of events, the immigration department would assign this or forward this web form with evidence to the officer tasked with your application, and they would decide what to do. Practically speaking, that does not happen. It's kind of what I said earlier, which is even the request for status, the target being 28 days, is being ignored. This is very serious because if you do have a serious prejudice to your delayed visa application, then there's really not much else to do, which leads you to making what's called a formal demand letter saying, I'm being prejudiced. Please decide my application within 30 days, or else I will go to court. And this leads to my earlier observation, which is in 2023, the number of federal court applications for various things, such as refusals or delays, of all kinds of applications, such as temporary status, permanent resident status, they were up to about 16,000 court cases. So because of perhaps staffing issues or training issues, the immigration department cannot respond in a timely way, and those with the financial means and with the substantive evidence to present prejudice have availed the other avenue, more expensive avenue, which is proceeding to federal court. So that is sort of the long contextual answer to the question, which I think is captured in the microcosm of this question, which is how do I deal with a lengthy processing time for my particular type of visa application. So I'll, hopefully, if there's a follow-up, please feel to put that in the chat, but I'll just see if there's an additional question here. So I think this relates to the previous question about the PR processing time, which is that if you have an IRCC work visa, can you apply for yourself into the express entry draw? So this question relates to, if I rephrase it, is what is the criteria or the prerequisites for an express entry profile? So there are certain fundamentals that have to go in. The criterion-based one is which set of criteria do you fall under? So, for example, there's Canada Experience Class, and that means you have 1 year of full-time work experience in Canada. That's one pathway. The other one is Federal Skilled Worker, where you have 1 year of foreign skilled work experience at a NOC tier level 3 or higher. And there's also a federal skilled trades where you may have a job offer from a province in one of the more technical occupations like welding or things of that nature. And those are sort of the conduits of what has to initially be the component of an express entry profile. And thereafter, there are certain standard documents, such as a valid passport, valid for more than 6 months, proof of a language test in English and or French, a précis of the work experience, so that you can credibly put down what your work experience is. And with those basic documents, you can have an express entry profile. And then you're the beneficiary of that profile for 1 year. And as I mentioned previously, the express entry profiles in the norm are usually about twice a month. And based on your work experience and English language level, and other factors too, such as whether you completed education in Canada, your level of education, whether you have a brother or sister in Canada, whether you have a certificate of nomination from a province, which gives you 600 points. Based on all of those factors, you will have a certain comprehensive ranking score. And if it exceeds the score that the draw has, for example, I think in December, the score was 570. So if your point total, based on your language, work experience, and education exceeded 570, then you'd be invited to apply for permanent residency. And then you'd have the 60 days for the EAPR, electronic application for permanent residency. And hopefully it gets processed within 6 months, as I previously mentioned. So that gives a little bit more context to the kind of steps and scope for starting from work permit through express entry to permanent residency. So hopefully that gives enough response to that particular question, and I'll take another look here, right? Then if I look at another question here, the person saying, I completed my post-graduation from Saskatchewan and possessing a work permit and doing a tier 1 job in Toronto from December 2022. And in my mind's eye, now it's more than a year. So the question is, what is the pathway now, given that the comprehensive ranking score is too high, and there's a sort of optimistic hope about whether there is a pathway of TR to PR or any other pathway through the Ontario Immigration Nominee Program. So this is a common question that we've been receiving since November, and that coincides with the fact that the CRS scores for express entry have been exceedingly high, and there is a genuine concern by candidates who paid for international studies, international student fees, and were perhaps promised with maybe even in no uncertain terms that this was a definite pathway for permanent residency, namely graduating from a school, publicly funded school, getting the 3-year work permit, and then based on the 1 or 2 years or 3 years of work experience, going under the CEC category of express entry. This has created false hope now. As I might have touched upon at the beginning of this presentation, Canada's policies are subject to international activity and ecological activity. So what comes to mind is, I'm going to stereotype based on the name, the person is from a South Asian country. There was a diplomatic row between Canada and India because India assassinated a Canadian citizen, which is a violation of Canada's sovereignty by killing somebody in Canada. So there was various political posturings between the two governments, and that led to expulsion of Canadian diplomats, and that was preceded by a flood of primarily Indian nationals between 2016 and 2020, who, because there was a well-staffed office in in India, a flood of Indian candidates. And now the tide is turning, and the policies are shifting based on these international political effects on Canadian immigration. And the Canadian government may not have the same priorities now, because they have to look after the rights of Canadians, Canadian citizens, and permanent residents. Temporary residents in Canada do not have the privilege of voting. And so there's going to be a huge struggle for many of these foreign nationals who had the expectation, like some of their friends might have, who were successful perhaps 2 years ago, who did use CEC as a pathway for acquiring permanent residency. So that's the context. But that being said, what do you do now? You have to think strategically. So thinking strategically also means being realistic based on your personal skills and based on your financial circumstances. So, for example, in terms of personal skills, can you rewrite the language test? If you're good at languages, can you write the French test? There's an inordinately large amount of weight given to language skills. There are separate programs incentivizing French language speakers. If you looked at the draws in December, there's a very low ranking draw. You needed a lot less points if you had French language skills for certain programs. Thinking further, where did you study? In this case, you studied in Saskatchewan. Some programs, provincial nominee programs, if you work in those provinces, you only need 6 months of work experience, unlike the federal CEC program, which requires 1 year of work experience at a suitable NOC level. In some cases, if none of these things work, if you cannot increase your score, keep in mind that there are other factors that are working against you, like the passage of time. The express entry point system favors people who are basically around 29 or less in terms of age. You'd have to consider, do you have more resources financially? Some provinces like British Columbia and Ontario have master's or PhD programs. I mean, that's a very long and expensive pathway, but it's a virtual guarantee. If you graduate in a master's program in those provinces, there's a specific pathway for those people. If you're really resourceful and adaptable, there are low-skilled programs in some provinces like Ontario and Alberta. Some of them target skilled jobs like welding or long-haul truck driving. If you're in Canada now, if you're able to take a course under 6 months for truck driving or welding, if you have that temperament for those types of skills, then you could use your ability to remain in Canada and work, take a course of less than 6 months, assuming the courses for those are less than 6 months, and see if you could acquire those skills for these lower skilled jobs. This kind of advice varies from person to person because some people may not have this problem at all. A lot of the jobs being targeted require a lower point threshold because in May of 2023, the Canadian government started to create targeted draws. So they give you a lower point threshold requirement if you had certain types of skills, like STEM-based jobs, science, technology, engineering, medicine, healthcare occupations, and things of that nature. So there were targeted draws where you needed lower points. Again, the Canadian government has to serve the labor market of Canada. So they're well within their rights to target certain occupations to the detriment of those people who perhaps took jobs, or rather, who perhaps studied financial-based jobs at colleges and were hoping to get permanent residency based on having a financial-based job. And those, I think, are the category that probably is suffering the most in terms of candidates who took a lot of years of studying in financial, economic-based occupations, and now are being stuck with the requirement to have the higher point total, which effectively excludes them from permanent residency. So if we think further, let's say you don't have good English, or you can't upgrade your skills, you can't change your skills, you can't do French, you're not lucky enough to get a job in Saskatchewan or the other provinces, or you can't, I left out the other one, where you get a labor market impact assessment, which is quite rare, to be honest with you, or you get the provincial version of that, which is an employer screened by a province, be it in the Times or the other provinces. and hence are allowed to give you a certified job, which gets you the points under a provincial system. Let's say none of those work, and you can't afford to go back to school for a master's program. Then what do? Then, in that case, again, thinking strategically, if you're under the age of 27, you could leave Canada. You could acquire skilled work outside of Canada. Express entry does give credit for 3 years of work experience in the last 10 years outside of Canada. And you could still have another express entry profile, but this time not under CEC, because you can only have a CEC profile within 3 years of the Canadian work experience, but rather under a federal skilled worker. So you'd have another express entry profile. After accumulating 1 or 2 years of work experience in this scenario, then you might be 29 or 30. You might have a competitive profile still. That's really all I can say. The rest is speculative. I think the other question talked about whether there's a TR to PR program, and that's a reference to the policy-based program, and this is a recurring theme in immigration, the sudden abrupt policy in February of 2021 to say, this is a free-for-all. You just need 75 points. You just have to have a pulse, have valid status in Canada, be on a study permit, and have worked some kind of job, and then you can apply for PR. And that policy was coinciding with the need to increase the number of permanent residents in Canada because the pathways were shut down because nobody could travel. So that cohort of permanent resident applicants who would come as skilled workers from outside of Canada was completely cut off for a number of months because there was no vaccine for 8 months. So out of desperation, those people who were lucky enough to be in Canada, who had valid status and who maybe worked in one of those frontline dangerous jobs, which did include cashier, which was a lot of people, they were able to benefit from that abrupt policy, which was a response to COVID-19. So looking on the cautiously optimistic bright side, there could be a policy. There was an announcement in December 23 by the minister about something very vague, some kind of pathway for permanent residency for people inside of Canada who did not necessarily have the steady, tried and true CEC pathway. But there's no details. So that's all I can say, I think, about the what to do in that kind of situation. Right? And I'll just proceed to see if there's another question. This might be related to the previous express entry question, and that is, do you have to wait a year before you apply for express entry? Or can you apply anytime during the IRCC work visa? So the answer for this is, generally speaking, you must have 1 year of Canadian work experience before applying for the CEC, unless you had 1 year of skilled work experience outside of Canada. And then you could put up a profile based on the federal skilled worker component of express entry. But mind you, based on my previous answer to the previous question, the amount of points you have may not be sufficient unless perhaps you are fluent in both official languages, have a master's level education, or 2 separate credentials, have perhaps 3 years of work experience outside of Canada. Then conceivably you could be qualifying under the federal skilled worker, which does not require Canadian work experience. So, and I'll see if there's any further question. Oh, this again relates, I think, to what ability do you have to leave Canada while you have a permanent resident application in process? And so for this, a lot of this depends on the type of category you've applied under. So I'm going to presume for the moment this is one of the skilled worker or CEC economic categories for immigration. So if it is, CEC, then in that scenario, you've put up an express entry profile, and I'm reading into this. You've put up the express entry profile, you got the invitation to apply, you filed for the permanent residency, and you're awaiting the decision. In that circumstance, you can leave Canada because your application was based on the work experience and credentials accumulated before you left, and they were locked in when you filed that electronic application. So you're just awaiting the decision. So you could leave. It would not affect your ability to qualify under CEC. By contrast, the requirement to stay might be mandatory if you applied under provincial nominee program, because one concern for provincial nominee government officials is, are you going to stay in that province? So if you leave Canada or move to another province, then that could jeopardize your provincial nominee program based application for permanent residency. Another category that comes to mind is the inside of Canada spousal or common law permanent resident application. On the face of it, the legislation says you have to remain in Canada while the application is going on. Hence, if you leave and if they discover that, they might refuse your application for permanent residency. So that's just a little bit of context to these this somewhat pertinent question for people who have the ability and the need to travel while they have a permanent resident case in process. So that being said, I think there's a related question to what to do if you don't think you have the points, which is namely, what is the international student stream of OINP? So that's the Ontario Immigration Nominee Program. And the international student stream for Ontario prioritizes people who have an express entry profile and they have a certain type of skill. And they've registered that they want to live in Ontario on their express entry profile. So if they possess a certain type of skill, and I believe in December 2023, one of the skills that this program targeted people for related to computer software or hardware, then you could get selected for permanent residency because Ontario noticed that your profile contained either work experience and or education in computer software or hardware engineering. And then you'd get selected without having to have the general score, which was much, much higher. And the threshold, the point threshold, I think varies. I think you had to have a minimum of 400 on your federal express entry profile to get selected, as long as you had computer software work experience. So that's sort of an example of how that would work. And I think it could relate to other categories like other jobs in demand, like welding, which is the example I've seen another candidate able to avail themselves under that OINP program. So I hope that gives a little bit of an example. It's not a comprehensive explanation, but it sort of gives an example of how the system works, right, for that particular type of permanent resident application. So that being said, let's take a quick scan of any other questions. So I still have time. So the kind of recurring theme that I see in terms of the future with immigration will be kind of what you're seeing here. More and more policy-based programs which wreak havoc with everybody because, for example, the Gaza-based program was restricted to 1,000 candidates subject to various exclusions. And similarly, these other programs for permanent residency, one that was intimated by the minister in December 2023, provided no time frame, no details. We see this over and over. There was a program announced for people affected by the instability in Sudan. On December 28th, they said there's a program for permanent residency. And now it's the middle of January. They said they're going to give specifics in February. But the way it'll work, probably, if we look at the way they're rolling out these other programs, is they'll say, fill out this form and have a Canadian person promise that they'll support you, and there'll be a cap, and the number will be small. The applications, some won't qualify. They'll have to increase the cap because not as many people qualified under the program. And it leads to instability because then, as lawyers, part of our job ends up being just monitoring the policies coming out, having alerts for any policy that's coming out and amendments to the policies and things of that nature. So sometimes if I'm not on the ball looking at the policies as they're being deployed, I'll have somebody call me the day of a policy and say, what about this policy? And I won't know what they're talking about because it came out literally like an hour before. Then I'll have to look up what is being said. And when you put a lawyer's lens on the policy, then you discover that it's couched in a certain kind of ambiguity. And then you're left breaking the news to the candidate, the would-be candidate, that the specifics are not there yet, and we have to wait for the more substantive policy. So that's sort of what I'll be seeing more and more of, I anticipate, in the future. So I'll just take another peek here, right? Oh yeah, so another one's related to permanent residency. So if somebody's living in Alberta and they only need 6 months of work experience, yeah, I believe that's correct. The prairie provinces, I think possibly Saskatchewan as well. If you're working and you have 6 months of experience, then there is a pathway. Now, for one or the other, it might mean there might be an additional requirement, namely that you'd have to have graduated from that province to get availability in that program. So I don't recall off the top of my head which one that is. But again, when you think about why this is happening, why does that province have that program? It's because they see you've graduated in the province, you're working in the province. They want to entice you right away with this carrot saying, look, forget about federal express entry /CEC. You can apply now. So that's the policy reasoning for having that kind of program. So then you'll get the PR, and they'll be satisfied that you're going to be staying in that job for a while because, practically speaking, if you're a young person, you need to get your Canadian work experience resume in place. So you're going to be working for a year and a half, perhaps, or two, before you move on to less icier pastures in British Columbia or Ontario. So that's sort of the policy rationale for these variations in the requirements for work experience, less for these less populated provinces, for example. Yeah, I think Alberta has, I think the Southern Ontario has 2/3 the population of Alberta or something like that. So anyways, that's sort of the policy reasoning behind these programs. And there's a myriad of other programs too. But a lot of them are job offer based. So even municipalities in small cities in Canada have their own immigration pathway they can articulate. But the rationale, though, is that the employer in that municipality has registered with the municipality, so the job offer is legitimate. And if your skills match that particular job offer, then that's a pathway to permanent residency. There was another program related to refugees who had nursing experience that was in the news. Again, these are very small programs, and they sort of come and go because there's caps on these programs. They fill up quickly. And it's a wonderful program. I mean, if you're in a refugee camp, you're a skilled doctor or nurse, then there was a pathway. I believe it was for the maritime provinces. So everybody wins because there's an aging population in Canada. You have highly skilled people outside of Canada. Uh, they're not using their skills. So it's a great program, but um, there's only a finite amount of spots for most of these programs. And there's always pushback um, because of the political climate, which is affected by the economic well-being of Canadians already here. So it's easy just to blame immigration or something for these economic woes, which are probably more a product of international economic activity. And immigration becomes vulnerable to these sorts of things, rightly or not, depending on whether there is some legitimate source for this. So you see that now with the shortage of housing in Canada, which was attributed to, I think, legitimately attributed to having too many temporary residents in Canada. It turns out, if you read the news, that the federal authorities did receive information that inviting too many temporary residents in Canada would affect the housing market. But hopefully that's for the short term, and that this will be sorted out. So again, this is part of the rationale for why there are so many policy-based programs, because they are often reacting to the complaints of one side versus the complaints of the other, and also reacting to ecological disasters and political catastrophes and things of that nature. And because Canada is a signatory to certain conventions, such as relating to refugees, then we have an obligation to react to certain events that take place internationally. That's the privilege of being in a country which has, I suppose, a conscience that has legislation that tries to be humane at times. So everybody has to sacrifice, and then some people are left in confusion or in the dark, and that's sort of the world we live in. It's sort of a microcosm of sorts. The various impacts on immigration policy in Canada. So that being said, I'll take another peek here because I'm only running a little short on time. So I don't see anything else in terms of the questions for this. So if there's any other question, please feel free, because I've allotted this amount of time for this month, another 7 or 8 minutes or so, to try to pose any general questions, because people are in general, and lawyers tell me this, who also do immigration, that there's a kind of love-hate relationship with lawyers, because, or any professional, because they possess specialized knowledge, and you have to pay to get the specialized knowledge, unfortunately, oftentimes, just because, like any professional, we have overhead. So people try to reach out to me sometimes on social media. I try to respond. If it's something very straightforward, I try to direct them to the immigration website. Some people get disappointed because they have a hyper-specific scenario with a lot of variables, and lawyers cannot advise unless they eliminate as many variables as possible. Otherwise, they're not helping themselves. They might end up giving advice that's wrong, that might be followed by somebody, and then the lawyer is left with a professional, loss of reputation, or maybe even a complaint on social media. So that's why lawyers have a kind of barrier that causes them to tread very carefully, because they're selling their time. That cliche is based on reality because of overhead being what it is. So I'll just take another look, right, for this. So it looks like a very specific question, right? So somebody has someone who applied and got invited for permanent residency under a specific NOC number rather than the one that they presumably placed in their profile. And the application was submitted based on the knock that was apparently arbitrarily selected by the immigration department. And then, I guess because of curiosity, the candidate, they applied for the Global Case Management System notes, and it showed eligibility was not met. So this reminds me of a federal court of appeal judge who dealt with an immigration or refugee case. I don't remember which. And the lawyer, as lawyers are tasked to do, they had an elaborate argument about how this was unfair. This was not the fault of the immigration department, or this was the fault of the immigration department. This was not the fault of the candidate. And then one element that deflated the argument was, well, what was the prejudice, or how did the candidate suffer? And if it was not a significant amount of prejudice, then the amount of fairness that is obligatory on the citizenship or immigration department is much lower. And the judge said that we're not expected to have, decision-making perfection on the part of immigration department officers. So in other words, it was couched in some ambiguity, but we can't always expect perfection. And unless there's some kind of prejudice, then there's really not much you can do, unless you can perhaps heed what the immigration department would say, or what the structure of the legislation would say, which is do another profile. Or if the officer did make a mistake and squarely ignored work experience in a qualifying knock tier level job, there's always judicial review. At judicial review, if you get leave, then if the mistake was particularly egregious, like a stupid mistake from a colloquial perspective, you could ask for costs on the basis of special reasons, saying this is patently unreasonable. The candidate explicitly expressed the knock number and explicitly had credible work experience related to that knock number. And there was prejudice because they could have gotten permanent residence sooner, and they've had to file a federal court case. So, I mean, that's a very narrow circumstance in which you could how to deal with this remedy or this impending refusal based on what you're seeing in the GCMS notes. So I think we're got a couple of minutes left. Let's take another peek right here. So I don't see any other question. So I hope this was of some utility to you. And I'm on social media, and the website is www.chaudharylaw.com. I think on Instagram is chaudhary.law. And I think on TikTok it's Toronto Immigration Lawyer. And I try to post